A very warm welcome to all of our viewers. I am Alind Chopra, the head of the media cell of the Libertatem, and we have with us Mr. Asim Pandya, the famous Gujarat High Court lawyer, who is with us for our very first video interview series. And we're great to have you with us today, sir.
Thank you very much.
Sir is a very renowned lawyer at the Gujarat High Court and a lot of other courts. Sir has been practicing for the past 25 years or so and has a huge number of books to his credit. Sir has written books on the law of bails, the law of contempt of court, etc. Sir, we're really pleased to have you with us today.
Thank you very much.
Sir, tell us more about your preschool law school era days. What motivated you to go to law school?
Actually, there was no motivation. It was by default I became a lawyer. And in school days, in college days, I was never a brilliant student. I think while doing LLB also, I just passed the LLB examinations without attending the classes. But in those days, after graduation, I had no choice. There were some lawyers from maternal side, so I thought that let me join this profession, except that there was no motivation.
Sir, also tell us about the transformation in the legal education scenario that existed at your time back in the 1980s in Mississippi, wherein the laws were probably not, the legal career was not taken up as seriously as it is today, the 5-year law course. Your views on that?
Okay. I did my study in 3 years law course, and as I can say that I hardly attended any class, any lecture, but those days were different. Now world is very competitive. People expect good things from lawyers, and they expect that lawyers should be very perfect. He can prepare his cases very well. Client would always insist. In those days, we were being taught only few subjects, namely Civil Procedure Code, Constitution of India, Criminal Procedure Code, Evidence Act, Transfer of Property Act, Succession Act, etc. Basic acts. I think in 5 years course, now more and more subjects have been introduced, and that would be very useful for the actual practitioners when they join the practice. So I think 5-year course is a better option instead of 3 years course, because in 3 years course we hardly learn anything. Our learning started after we joined the profession.
Sir, as a young lawyer who joined the bar after graduating fresh from law school, what challenges do you think you were faced with, and what challenges do young lawyers today face when they come out of college? Is the scenario more favorable to young lawyers today, or was it back then?
Actually, if you have no legal background, it is always difficult to sustain in this profession. When I joined this profession, there was nobody from my family who was a lawyer. So it was a very difficult job. It was a question of survival for me. So when I joined, for 1 year even I did not gain opportunity to even mention one case in the entire year in the court proceedings. And in the year 1990, my senior started paying me 500 rupees as stipend, just an incentive. So those were the challenges, and during the entire year we may have to sit and wait for the clients to come if you have no legal background. So I utilized that period of waiting in writing a book on excise law, and that's how I started. I thought that it would be better if I write something. It would be possible for me to survive in the profession. I also did LLM, thought that if I want to survive in this profession, I would at least get part-time lecturership in the college, and that is how I would be able to survive. That was the challenge in those days. Right now also, if you are a fresh graduate from 5 years course, of course your training would be better. You might have attended MOOC course, you might have done your study very sincerely. So those are the positive factors, but when it comes to actual practice, it is always difficult to get a client. Client would not repose trust immediately. So merely because you are well trained, that does not necessarily bring clients. So that is still the position is the same for the freshers if you have no legal background.
Okay, sir. Sir, also tell us, in your position as a lawyer, have you been faced with very morally tormenting questions where you found yourself on the verge of a sort of a ethical turmoil?
See, during my practice, I have always insisted for speaking truth. I have never given any advice to my client which would be wrong. If I am sure, then only I would accept the brief. And my reputation in the court is also that when Mr. Pandya speaks in the court, usually court would believe that okay, he would be speaking true. So as such, I have not come across any ethical issues. And being a lawyer, as such, we are supposed to accept each and every brief. Sometimes people may ask me that if you know that somebody has done something or he has committed some crime, then why do you accept the brief? And my answer would be that we are not supposed to change the facts. On the basis of the facts which are made available to us, we are just pleading the legal issues in the court. So as such, there are no ethical issues which I have been confronted at all. So that is the answer.
Okay. Sir, also like you've had the opportunity of working on a lot of cases, any one of which you had special interest in or that you had has become your favorite case?
Actually, after joining this profession, as I said, that it was a question of survival. So gradually I started liking this profession, so it became my hobby. So every case I enjoy very much.
Okay, sir. So if you remember correctly, and in 2011, the Indian Express reported you as saying that the current system back then, what it used to be of selection of judges to the higher judiciary, was very political in nature. Now that a new bill has been passed by the Parliament, the National Judicial Appointment Commission Bill, what is your take on it?
Actually, I was not entirely against the collegium system. I was against the non-transparent system, because collegium system itself is not objectionable, but the non-transparency which was pervading in that process was objectionable, and my petition was not for seeking an appointment. I wanted that this system should be more transparent, because once we are invited for being a judge of the High Court, our names are sent to the three consultees as contemplated under the Constitution of India, namely Governor, President of India, Chief Justice of Supreme Court. So when these files go to these consultees, they are supposed to just ascertain whether this person deserves to be appointed or not. At that time, sometimes for political reasons, some people put forward certain political type of objections if they don't want a particular candidate to be appointed in the higher judiciary. When these kind of objections are placed before the consultees, then there is no mechanism whereby an explanation is called for from the candidate whose name has been sent. So in presidential reference, that is third judge's case. First was SP Gupta, second is that Supreme Court's Advocate Association, third one is presidential reference. In that case, there is one paragraph where it has been stated that if Chief Justice finds that some objections have been raised against a particular candidate, he can seek explanation from him. So that would be in tune with the principle of natural justice. Second insistence was that if appointment is not done, then in that case at least courtesy demands that candidate whose name has been forwarded should be at least intimated that we regret we are unable to appoint you. They may not disclose any reason, but my third issue was that they are supposed to disclose the reasons also, because in the era of Right to Information Act, I must, being a candidate, must know what were the reasons that had weighed with the consultees who has ultimately made up mind not to appoint. So those were the things. I never wanted that I should be appointed. I did not want, and by Supreme Court's judgment, the scope of judicial review has also been narrowed down in respect of appointment of judges. So all those things were objectionable, and therefore I filed a petition without success. But ultimately, what I wanted has come true by the form of National Judicial Commission.
Okay, sir. Any advice that you would want to give to young or fresh graduates from law school and law students across India?
Across India or anywhere, I would always suggest have an ethical practice, have faith, and speak truth only. Because in these days, what is lacking is lack of character. You will not find a person who is having a good character and who is very honest. So if you are just honest, that would definitely pay you in future. So I would request all of you to remain honest and stick to honesty.
Okay, sir. Thank you so much for sharing your experiences with us. It was a pleasure talking to you.
Thank you very much.
Thank you.